Across social media and breaking news feeds, a dramatic claim begins to spread. A United States president has demanded the immediate arrest of Todd Blanche, a prominent defense attorney, following what is being described as a courtroom disaster. The allegation moves quickly, amplified by commentary, speculation, and political interpretation, turning a single moment inside a courtroom into a national conversation about power, accountability, and control. At the center of it all is Todd Blanche, a well-connected legal figure known for operating at the highest levels of the American justice system. But almost immediately, a contradiction emerges. In the United States, can any president actually order someone's arrest? The question cuts to the core of how power really works. Is this an example of direct authority being exercised, a misunderstanding of legal limits, or something more calculated? Because in modern politics, statements are rarely just statements. They can signal intent, apply pressure, or reshape the narrative long before any formal action takes place. What most people miss is that even if this never happened, the fact that people believe it could reveals something far more significant about the system itself. To understand whether a claim like this is even possible, we have to separate what actually occurred from what is being suggested. And that is where the story begins to change. Because the gap between perception and reality is not just a legal question, it is a strategic one. And once that gap opens, it has consequences that extend far beyond a single courtroom or a single individual. Those consequences are what make this story more important than it appears. To understand the claim, we have to start with what is actually known. Todd Blanche is not a fringe figure operating on the margins of the legal system. He is a senior defense attorney who has represented high-profile clients, including Donald Trump, and has worked inside some of the most scrutinized legal proceedings in the United States. That context matters because it places him at the center of an already charged legal and political environment. Multiple cases involving Trump and his associates are moving through the courts, each attracting intense media coverage and partisan interpretation. In such an environment, even routine courtroom developments can be reframed as dramatic turning points. So what actually happened? Publicly available information points to standard legal proceedings, arguments, and procedural disputes, not a singular catastrophic event that would justify extraordinary intervention. Yet as clips, headlines, and commentary circulated, the narrative began to shift. Interpretation blurred into assertion, and assertion into something closer to fact in the public imagination. This is where the distinction becomes critical. There are verified events, there are interpretations layered onto those events, and then there are claims that extend far beyond what evidence supports. Legal experts consistently emphasize a basic principle. Arrests in the United States follow legal process, not direct presidential command. But that has not slowed the spread of the story. Because narratives, especially in politically polarized environments, evolve faster than facts can be verified or explained. And once a narrative takes hold, its influence is no longer dependent on accuracy alone. But even if the claim itself does not hold up, the deeper issue is why it sounds believable to millions of people. To understand that, we have to look beyond the immediate moment and examine how presidential power over the justice system has evolved. That history reveals a long tension between formal authority and informal influence, where perception, precedent, and political pressure often shape outcomes as much as written law, setting the stage for why such claims gain traction today, even when they conflict with reality. The idea that a president could directly order an arrest runs into one of the oldest design features of the American system, the separation of powers. From the beginning, the Constitution divided authority between the executive, legislative, and judicial branches, not simply to distribute power, but to prevent its concentration. Law enforcement sits in a more complicated space. The president oversees the executive branch, which includes the Department of Justice. Yet prosecutions and arrests are constrained by legal standards, judicial oversight, and procedural rules. In theory, this creates distance between political leadership and legal outcomes. In practice, that distance has always been contested. The Department of Justice itself reflects this tension. Formally, it is part of the executive branch, and the Attorney General serves at the pleasure of the president. Informally, however, it operates under a long-standing expectation of independence, particularly in criminal cases. That expectation is not fully codified in law. It is sustained by norms, traditions, and the professional culture of prosecutors. And those norms have been tested before. During Watergate, President Richard Nixon attempted to influence the course of a criminal investigation tied directly to his administration. The result was not just a legal crisis, but a constitutional one, culminating in resignations, public backlash, and ultimately Nixon's departure from office. The lesson was not simply that presidents lack authority, but that using whatever authority they have to interfere with legal processes carries enormous political risk. More recent controversies have followed a similar pattern, though often less dramatic. Presidents have criticized investigations, commented on ongoing cases, and, at times, signaled preferences about outcomes. These actions rarely translate into direct legal control, but they do exert pressure both publicly and internally. This is where the distinction becomes essential. Legal authority defines what a president can formally do. Political pressure reflects what a president can attempt to influence. Institutional norms determine how far that influence is allowed to go before resistance emerges. When those norms are strong, the system absorbs pressure without breaking. When they weaken, the boundary between influence and control becomes less clear. Public perception does not always track these nuances. To many observers, the president's visibility and authority suggest a level of control that does not fully exist in practice. That gap between perception and legal reality creates space for narratives that overstate executive power. This is where the distinction becomes critical. The president has influence, but not control. And confusing the two changes everything. Because once influence is perceived as control, statements can be interpreted as actions, and rhetoric can be mistaken for authority. With that context in place, the focus shifts away from whether such a claim is technically possible and toward a more revealing question: why narratives like this emerge, and what strategic purpose they serve in an increasingly contested political environment. At a surface level, the claim appears to be about an arrest that likely never happened. But at a deeper level, it reveals something far more consequential: how power is communicated, perceived, and strategically deployed. Because in modern political environments, especially those shaped by constant media exposure, statements are rarely just descriptive. They are performative. They are designed to project strength, signal intent, and shape expectations. From a political messaging standpoint, the idea of demanding an arrest conveys decisiveness. It suggests control over events, dominance over opponents, and a willingness to act without hesitation. Whether or not such authority actually exists becomes almost secondary to the image it creates. This is the contrast at the heart of the story. The public narrative suggests immediate, decisive action. The strategic reality is far more constrained, bounded by legal procedures, institutional safeguards, and the limits of executive power. But perception does not operate on legal nuance. It operates on clarity, emotion, and repetition, and that creates incentives for political actors. Framing a situation in absolute terms can consolidate support, especially during legal battles where outcomes are uncertain and timelines are slow. A courtroom is governed by rules and delays. Public opinion, by contrast, moves quickly and can be shaped in real time. That makes narrative control a form of strategic leverage. In this context, even an alleged statement about ordering an arrest can function as a signal to supporters. It signals strength and commitment. To opponents, it signals confrontation. To institutions, it can act as a form of pressure, testing how firmly boundaries will be enforced. None of this requires the statement to translate into action. Its impact lies in how it is interpreted. This is where media ecosystems play a decisive role. Highly polarized information environments tend to amplify conflict-driven narratives. Claims that reinforce existing beliefs spread faster, encounter less skepticism, and are repeated with greater certainty. Over time, repetition can blur the distinction between what was said, what was implied, and what actually occurred. The result is a feedback loop. Narratives generate attention. Attention reinforces narratives. And each cycle increases the perceived plausibility of the underlying claim. Inside this loop, perceived authority can begin to outweigh actual authority. For the general public, the difference between influence and control becomes less visible. But for legal professionals, policymakers, and institutional actors, that difference remains critical. They interpret such signals differently. Where the public may see a direct order, insiders often see an attempt to shape the environment around a legal process. They recognize the constraints, but also the potential risks if those constraints are repeatedly challenged, because even without direct action, sustained pressure can have indirect effects. It can erode confidence in institutions, create hesitation among officials, and shift the baseline of what is considered acceptable political behavior. This is where the concept of narrative warfare becomes relevant. Traditionally associated with international competition, narrative warfare is increasingly visible within domestic politics. Competing actors attempt to define reality itself, framing events in ways that advance their strategic position. In that sense, the claim about an arrest is not just misinformation or exaggeration. It is part of a broader contest over interpretation. Who has power? How is that power exercised? And where are its limits? Institutional resilience depends not only on formal rules, but on shared understanding of those limits. When that understanding fragments, the system becomes more vulnerable to pressure, even if its formal structures remain intact. But here's the deeper issue. In geopolitics, perception often matters more than reality, and this is where the real consequences begin. Because once perception shifts, it does not stay contained within rhetoric. It begins to influence behavior, expectations, and ultimately, outcomes. And that is when a narrative stops being a story and starts becoming a strategic factor in its own right. Once that threshold is crossed, the implications extend far beyond a single claim or a single courtroom, reshaping how power itself is understood and contested. When narratives begin to blur the line between political authority and legal process, the consequences extend far beyond a single claim. They begin to affect how the entire system is perceived, both internally and externally. Domestically, trust in institutions becomes the first point of strain. The rule of law depends not only on formal procedures, but on public confidence that those procedures are applied consistently. When large segments of the population begin to believe that arrests, prosecutions, or legal outcomes can be directed by political figures, that confidence weakens. Over time, this accelerates polarization as competing groups adopt fundamentally different understandings of how the system operates. Inside the legal system, the effects are more subtle but equally significant. Judges, prosecutors, and defense attorneys operate within a framework that assumes independence from political pressure. But when narratives suggest that outcomes are politically driven, even indirectly, it can create an atmosphere of scrutiny and tension. Decisions are no longer evaluated solely on legal merit, but through a political lens. Internationally, the implications are even broader. The United States has long positioned itself as a model of legal stability, where institutions function predictably, regardless of political leadership. That perception underpins diplomatic credibility, economic partnerships, and global influence. If that image begins to erode, allies may become more cautious, while rivals may see opportunity. Because in global politics, institutional legitimacy is not just a domestic concern, it is a strategic asset. Investors, for example, rely on the predictability of legal systems. Contracts, disputes, and regulatory decisions all depend on the assumption that rules are enforced consistently. If political influence is perceived to override legal norms, even occasionally, it introduces uncertainty. And uncertainty carries economic cost. There is also a contrast that becomes increasingly difficult to ignore. In the short term, strong political messaging can mobilize support and shape public narratives. But in the long term, repeated challenges to institutional boundaries can weaken the very structures that sustain national power. This pattern is not unique to the United States. In other countries where political interference in legal systems has become normalized, the result is often a gradual decline in institutional credibility. followed by reduced investor confidence and diminished global influence. The difference is that for the United States, the stakes are higher. Its global role is tied not just to military or economic strength, but to the perception of stability and reliability. Soft power, the ability to influence others without coercion, depends heavily on that perception. If it weakens, so does the broader strategic position of the country. At the same time, internal polarization becomes more than a political issue. It begins to take on national security dimensions. A divided public, operating on incompatible versions of reality, makes coordinated responses to external challenges more difficult. This isn't just about one case, it's about whether the system itself is seen as predictable. And once predictability comes into question, the effects ripple outward, shaping decisions in courtrooms, boardrooms, and foreign capitals alike. Which leads to the next and most consequential issue. If these dynamics continue, what happens next? Once a narrative like this takes hold, its trajectory depends less on any single event and more on how institutions, political actors, and the public respond over time. Several plausible paths begin to emerge. The first is institutional containment. In this scenario, courts, the Department of Justice, and legal professionals continue to reinforce existing boundaries. Procedures are followed, rulings are grounded in law, and attempts to blur the line between rhetoric and authority are quietly but firmly resisted. Over time, the gap between claim and reality becomes clearer, and the narrative loses momentum. The system does not remain untouched, but it stabilizes. This outcome depends heavily on institutional confidence and the willingness of key actors to prioritize norms over short-term political pressure. The second scenario is more complex: escalating political pressure. Here, rhetoric intensifies rather than fades. Legal actors become more frequent targets of public criticism, and each new development is framed as part of a broader political struggle. Institutions continue to function, but under increasing strain. Decisions are scrutinized not just for legal reasoning, but for perceived alignment. The system holds, but at a cost. Polarization deepens, and public trust becomes more fragmented. In this environment, even routine legal outcomes carry amplified political consequences. The third scenario is the most gradual and potentially the most significant: norm erosion. This does not require dramatic institutional breakdown. Instead, it unfolds over time as repeated challenges to legal boundaries shift expectations. What once seemed implausible begins to feel possible, then acceptable. The distinction between influence and control becomes less clear in public perception. Legal independence remains in place formally, but its credibility weakens. The result is increased unpredictability, not because the rules have disappeared, but because confidence in their application has declined. Across all three scenarios, several factors will shape the outcome. Courts play a central role, not only through decisions, but through consistency and clarity. Congress, while often constrained by political divisions, retains oversight authority that can either reinforce or undermine institutional balance. Public opinion acts as both a constraint and a driver, shaping how far political narratives can extend before encountering resistance. The media environment also matters. Amplification can either accelerate distortion or contribute to correction, depending on how information is presented and contested. Underlying all of this is a fundamental tension between legal safeguards and political realities. The system is designed to resist direct control, but it is not immune to sustained pressure. The outcome won't be decided in one courtroom, but across institutions, narratives, and public trust. And that brings the focus back to the central question behind the headline. Not as a matter of fact, but as a reflection of how power is understood, interpreted, and ultimately exercised. In the end, the significance of the claim is not determined by whether it is true, but by why it felt believable in the first place. A statement about ordering an arrest, even if unfounded, resonates because it aligns with a broader perception that power can override process. And that perception, once established, begins to shape how people interpret events, institutions, and authority itself. But the strength of a system like that of the United States has never rested on the raw power of its leaders. It rests on limits on the idea that no individual, regardless of position, can unilaterally control legal outcomes. That distinction is easy to overlook, especially in moments of political intensity. Yet it is precisely those limits that create legitimacy. Without them, power may appear stronger in the short term, but it becomes less stable over time. This is the underlying tension between narrative and reality. Narratives can simplify, amplify, and distort. Reality, particularly in legal systems, is slower, more constrained, and often less dramatic. But over time, narratives have the ability to reshape expectations, and expectations, in turn, influence behavior. That is how boundaries shift, not always through formal change, but through gradual redefinition. The endurance of institutions depends on resisting that drift, maintaining a clear separation between what can be said and what can actually be done. Because the real question isn't whether a president can order an arrest, it's what happens when enough people believe they can. The answer to that question will not emerge from a single event, but from how consistently those limits are tested, defended, and understood in the years ahead.